versus Ryan Busick.
Alexander on behalf of the people, Your Honor.
And good afternoon, Your Honor. Miles Drew on behalf of Mr. Busick, who is standing to my right, P number 84554. Mr. Busick, could you please state your name for the record?
Ryan Michael Busick.
And Your Honor, I do believe that your staff should have in their possession by now a substitution of counsel. I was retained yesterday on Mr. Busick's case, and I believe I have received all the documents the public defender's office had from the prosecutors related to their motion. If you don't, I do have a blank copy. It appears my staff had the judge's name, but I do have a blank copy that I'd be able to sign and provide to the court now.
Whoa! New defense counsel just retained yesterday. That means one thing. This case is heating up fast. But think about it. Would you want to step into a legal wildfire with barely a day's notice? Risky move or smart strategy? What do you think?
Do you see it?
No, I do not see it.
84554.
Mr. Kearney, could you sign off on that?
Thank you. Okay. Yeah, happy to put it on a CAO form. Okay. Have a nice one. In Your Honor, may I approach?
Yes.
Oh,
Well, that's okay.
thank you, officer.
It's all excited.
Gotcha. Okay. All right. Okay. I will sign off on that, but we can proceed at this point. All right.
Thank you, Your Honor.
This is the people's motion. You're prepared to argue it at this point?
Yes, I am, Your Honor.
Counsel, did you receive
Hold up. Emails with video attachments being sent directly to the court? That's not just chaotic. It hints at obsession. In legal terms, it undermines trust between client and counsel. And trust me, judges hate being put in the middle like this.
copies of emails that your client had been forwarding to the court? I think we sent those to the prosecutor.
Correct, Your Honor. I believe that was yesterday.
Yes, I'm in receipt of one email to the court, a copy of the prosecutor's motion with one exhibit attached to it, and then a copy of the police report and the information.
Well, I don't know at what point you got that, because there were 3 emails to the court.
Oh, there was. I am only aware of one email.
Video attachment.
And
I have the one with the video attached.
There were 2 after that.
there were 2 after that.
May we briefly go off the record so I can review these 2 other emails, Your Honor?
Yeah, what are did you have copies of them?
What was that?
I have copies, Your Honor.
Okay.
Email.
Can we, I've got our copies, so I'm going to step off then so that he can go through that and talk with his client before we continue on.
Thank you for that opportunity.
Court stands in recess.
Alexander on behalf of the people, Your Honor.
And good afternoon again, Your Honor. Miles Drew on behalf of Mr. Busick, who's approaching my right. And could you please state your name for the record?
Ryan Michael Busick.
All right, thank you. Go ahead. This is your motions.
Thank you, Your Honor. At this time, people are going to be requesting our original request of a $50,000 surety bond.
The next few moments describe events that are both shocking and deeply troubling. Listen closely, not just to the charges, but for the language used. It reveals a disturbing pattern of control and escalation.
In this case, defendant was granted a PR bond. However, the facts of this case are extremely concerning. In this case, the defendant went to the victim's residence and was, in this case, defendant was granted a PR bond. However, the facts of this case are extremely concerning. In this case, the defendant went to the victim's residence and was almost interrogating her and accusing her of infidelity. He banged on the door, was told to leave by her. He then forced his way into the home, breaking the door. Officers, when they arrived, saw broken drywall. The door was off the frame. The lock, the deadbolt was still in the lock position. After entering the house, the defendant then grabbed the victim and threw her onto a bed and was continuing to interrogate her about who she had at the residence. He then pulled down his pants and underwear to his knees, exposing himself, and she stated that he then tried to rape her. While this was happening, he was continuing to interrogate her about infidelity. She was then able to kick the defendant, run away out of the room, and exit the home, where she began to yell for help. Neighbors heard her calling for help. After that, the defendant then chased her down and tried to stop her by grabbing her arm, causing her to fall. Law enforcement arrived shortly after, and in the videos, see that it was raining, and they were both covered in rain, I guess water, I don't know. But it's very concerning, especially given that there was the broken door. And then not only after that, when he gets into custody, one of the 2 calls he makes, while one of them was prior to bond conditions, it was concerning to the people, given that in that call, he continues that line of interrogation of accusing her of cheating and infidelity on the jail calls. And then the next day when he's arraigned, after he's arraigned, he calls her again, violating his bond.
Did you catch that? Even after being arrested, he still called the victim, accusing her again. This isn't just a legal violation. It shows a mindset that refuses to let go. Do you think this is obsession or something more sinister?
And it just seems, especially given these emails that we received yesterday, he has this obsessive disposition with this victim, and it's very concerning to people given the facts of this case and his actions after this case occurs. So at this time, we're going to be re-requesting our $50,000 request. I believe that a personal recognizance bond was discretion, Your Honor.
Ms. Ross.
And Your Honor, we would admit that there was a call that occurred on the jail line, the one call that is a violation of the court's bond conditions for the no contact. I would note that all the allegations the prosecutor has gone over as it relates to the bond violations were prior to me being retained as counsel. Mr. Busick's a lifelong resident of Ypsilanti. He has a clean eye chat that I've seen, meaning he has no priors and accordingly no capious history. While this is a very serious charge, and Mr. Busick does contest the allegations and is serious about facing them as evidenced by retaining counsel, I would note that there was no injuries or medical treatment and that Mr. Busick did comply with police officers. While I'm not here to litigate the facts of this case in a bond hearing, I think it's evident from looking at this case and the pending case against the complaining witness, where my client is the victim, that they have a dysfunctional long-term relationship that will no longer work out in any capacity as a romantic relationship. I've expressed that to Mr. Busick, and he's been receptive to that feedback. I think it's clear that neither party has treated each other very well. He is living currently in Ypsilanti with his mother, Lisa, who's in court today, his stepdad, Doug, who is also in court today, sister Chelsea, who is not here, but has been in constant communication in my office. His sister Erica is here in court, so he has strong family support in this matter. He does have two children with the complaining witness in this matter, his son Matthew, 4 years old, and daughter Scarlett, 2 years old. It's a shared custody situation where he has the kids on the weekend and about 2 or 3 nights during the week. His mom and sister are facilitating those custody exchanges, and I have expressed not only to Mr. Busick, but to the family the importance of the no contact order, including that it means no third party contact, and have instructed the family not to discuss this case in any capacity whatsoever with the complaining witness. As for work, Mr. Busick is a journeyman carpenter with the Regional Carpenters and Millwright Union. He has over 10 years experience and 6 years with the union. He has good health coverage through his job that provides for not only him, but his children with the complaining witness. It's our understanding that the complaining witness does not work. And even though there's no child support order in place, he does also provide support to the mother of his children for expenses when she has the kids in her possession. In other words, he is the provider for these children, and they get their health insurance through his job. And that appears to be the only avenue for their health insurance. And he is at risk of losing this job should he go to jail.
So let's break this down. He's got no priors, a stable job, and a full family in court for support. But serious allegations and bond violations hang over everything. This is where courts have to balance safety, intent, and second chances. What would you decide?
So, Your Honor, I would, conclude by saying that counsel was retained after all these allegations, that Mr. Busick has no prior criminal record. And I think him and the family maybe didn't understand the scope and importance and severity of a no contact order. I have counseled them at length about that no contact means for any reason.
What you have understood about that, counsel?
Your Honor, I think it's somewhat common for people. I know no contact means no contact, and it's very straightforward, but I think people that have no prior history with the criminal justice system sometimes do not think things are as straightforward as they are. He certainly makes no excuses for his behavior, and he knows it's inexcusable to make those calls. We would be asking for a $25,000, 10% with the tether.
But he's still, from the allegations, and I'm not making necessarily a presumption of his guilt of those, but he's making certain allegations regarding her infidelity, then ultimately gets arrested. After creating some damage or allegedly creating some damage to the premises, and things not going well because now you're in custody, you're told by the magistrate not to have contact, and what does he do? He has contact.
And despite everything, the arrest, the no contact order, He makes another call. Same accusations. Same pattern. This isn't just about legal consequences anymore. This is about willful defiance. What happens next could define the rest of his life.
About the same thing that the allegations are about.
Right. I understand the court's concerns. That's why we are asking for a cash bond in this matter. I would point out that, since he was assaulted in March by the complaining witness, which resulted in felonious charges, these have been some of the hardest and trying months of his life. He has not been in his right state of mind. We're going to be looking to getting him, treatment while on bond and getting evaluated for a treatment course so he can get some support in facing this tough time, Judge. Ultimately, there's no excuse for making the phone call on bond. We understand that the allegations are